Good afternoon, and thank you for joining us for an NP Wired for HR and the Home Care Alliance of Massachusetts sponsored webinar, HR Legislative Update for Health Services. I'm Lauren Thompson, Marketing Programs Manager here at MP. We help our clients succeed by aligning their people strategy with their business goals. Just a few housekeeping items before we get started here today. If you'd like to submit a question, please feel free to do so at the Q&A feature at the bottom of your screen. We will be sending out a recording of today's presentation after the webinar, along with slides. Here to introduce our guest for today's program is MPHR Solution Marketing Manager for Health Services, Celeste Begley.
Thank you, Lauren. And thank you all for joining us today for this important discussion. I'm thrilled to welcome you to our webinar on HR Legislative Update for Health Services. I am happy to introduce Harrison Collins, Director of Legislative and Public Affairs at the Home Care Alliance of Massachusetts. With years of experience and a deep commitment to improving home care services, Harrison has advocated for policies that enhance the quality and accessibility of home-based care. MP Wired for HR is proud to celebrate our strategic partnership with the Home Care Alliance and a collaboration that has flourished over the past few years. Aligned with HCA's mission, we provide innovative services designed to enhance the capabilities of home-based care providers, ensuring they deliver the highest quality of care. Harrison, thank you for being with us today.
Thank you very much for introducing me. Hi, as a reminder, my name is Harrison Collins. I'm the Director of Legislative and Public Affairs at the Home Care Alliance of Massachusetts. We represent about 180 to 190 home.
I think he might have frozen.
I think he did.
They are members. They have presented multiple times to our HR managers and attended our conferences. Thank you very much for us to be here.
Thank you. I am really pleased to introduce Amanda Leonardi, who will be presenting today. With almost a decade of experience in the HR field, Amanda has spent the last 5 years of her career at MP, where she currently serves as the HR Service Manager. Amanda is SHRM certified and has worked with a multitude of clients in various fields and industries to help them achieve peak HR compliance. Please join me in giving a warm welcome to Amanda Leonardi. The floor is yours.
All right. Thank you, Celeste, for the warm welcome, and good afternoon, everyone. As Celeste mentioned, my name is Amanda Leonardi. I am the HR Services Manager here at MP, and I'm so excited to be here with you all this afternoon. So thank you for taking the time out of your busy day to join us. I am going to kick us off with a little legal disclaimer here, because boy, do we have a lot of regulatory updates to talk about today. So, all of these agencies really know how to put a damper on the summer here, don't they? But just keep in mind that this training is intended for educational and informational purposes. While we hope that you will learn a lot today, I'm not an attorney, and the information that we talk about today should not be construed as legal advice, but I am a certified HR professional and hope you take a lot of great nuggets away from our session today from an HR best practices perspective. So you're probably all chomping at the bit to know what's in the lineup for today's session. So here is our agenda, and as you can see, we do have quite a bit of ground to cover today. So my apologies in advance if I am breezing through some of these topics. Please know that we'll get to some Q&A at the end, and anything we don't get to, make sure that we generate an FAQ document and get you the answers to your burning questions. So don't hesitate to submit those, as Lauren mentioned. All right, so agenda-wise, we're going to start with the federal overtime rule, the final regulations under the FLSA. Then we'll move to the Federal Trade Commission ban on non-compete agreements. We'll then jump to the Pregnant Workers Fairness Act and those final regulations. And then I will leave you all with a few cautionary tales at the end. And of course, we'll get to Q&A as time allows. All right, so let's do it. We're going to start today by First, talking about the final regulations to the federal overtime rule. Now, our team of, HR professionals here at MP have, we've been doing a lot of outreach to our client base on this topic over the past several months, as you can imagine. And, the one thing that we really noticed is that it became apparent that it was important to provide a refresher on the long-standing rules under the Federal Fair Labor and Standards Act, which from this point forward you'll hear me refer to as the FLSA. It's less of a tongue twister. So, and the FLSA governs these federal overtime rules. So we're going to start today off by a high-level overview of the general provisions of the FLSA first, and then we'll dive into, what's changed, and what will continue to change when it comes to these provisions over the next several months and even years. And we'll talk more about that shortly. But to kick us off, give us just a refresher. The Fair Labor Standards Act is the law at the federal level that governs minimum wage and overtime requirements. And it's been around since 1938, so for quite some time. And the purpose of the FLSA is to protect workers against unfair employment practices. And it establishes federal standards for minimum wage, overtime, record keeping, and youth employment. And in order to satisfy the FLSA, it's important to properly classify your employees as exempt or non-exempt. Now, oftentimes I hear, the terms exempt and non-exempt being used interchangeably with salaried employee and hourly employee, but it's actually much more involved and complicated than that. So I want to take a moment to kind of go through the definition of a non-exempt employee and the definition of an exempt employee, so we have a solid understanding of the difference between the two, so that you know how to approach these changes in the regs moving forward. So we'll start by talking about non-exempt employees. So for any of you who have LPNs in your workforce, the Department of Labor makes it very clear that LPNs must be classified as non-exempt employees. So definitely lock in on these next few slides, pay close attention, because this is something that we oftentimes see misclassified, with LPNs being exempt employees. Now, when we talk about non-exempt employees, this is the classification that is, commonly referred to as an hourly employee, but in actuality, non-exempt employees may be paid on an hourly basis, they may be paid on a salary basis, day rate, job rate, piece rate, or commission basis. Okay, so you can see that, despite the non-exempt classification, you don't necessarily need to pay non-exempt folks on an hourly basis. You can pay them in a variety of different ways. That said, employees must earn at least minimum wage for all hours worked, and non-exempt employees must be paid the appropriate overtime pay for hours worked over 40 in a work week. So for non-exempt folks, in order to meet those requirements, you have to track their time through some sort of timekeeping mechanism so that you can ensure that you're paying them, again, at least minimum wage for all hours worked, along with overtime pay for any hours worked over 40 in one work week. And overtime is paid at 1.5 times the employee's regular rate of pay. Now, for the sake of time today, we're not going to dive into how the regular rate of pay is calculated, but should it be a little bit more complicated for your organization and you need any information on this, we can certainly help at MP, and the Department of Labor also has some great resources on this topic as well. So that's my little homework action item for you. Make sure that you go back and take a look at the definition of that regular rate of pay, so you can really ensure that the folks that are classified as non-exempt are being compensated appropriately when it comes to overtime. Now, again, remember, not to sound like a broken record here, but non-exempt employees must earn minimum wage for all hours worked. And when we talk about the definition of hours worked, that includes things like waiting time, on-call time, right? So if you have a non-exempt employee performing on-call work where they are, in your office and sitting and essentially waiting to get that phone call in order to spring into action, that oftentimes needs to be compensated, right? That is considered hours worked. There are a few caveats when it comes to that, in terms of, if the on-call allows employees to go off and do their own thing and they don't need to be, holding themselves back from living life during that period of time. There are some loopholes there, but if they're on call and need to be locked in and ready and waiting for some needs to come through for work related purposes, then that generally is considered compensable time. Meal and rest periods too. If employees are sitting at their desk answering emails, or out on the road at a patient site during eating their meal there, that is considered work being performed during that time and is considered compensable as well. If they're fully able to disengage from work, would run to Jersey Mike's for a sandwich and do their own thing, and call their family or what, and not need to worry about work during that meal or rest period, then those can generally go unpaid. But if they're performing any type of work during a meal and rest period, that does need to be compensable. Training time is also considered compensable. Travel time is considered compensable, right? So in terms of travel time provisions, employees are generally responsible for getting themselves to work and from work at the beginning and end of each day. But any travel, and this comes into play very frequently in your industry, any type of travel in between the start and end of the workday is compensable, right? So they're on the clock while they're traveling. And also a little disclaimer too, in the state of Massachusetts, mileage is also required. So if they're using their personal vehicle for work, you need to pay them mileage for that travel as well. And then last but not least, sleep time is also considered compensable. So for example, my previous experience prior to coming to MP, I worked for a nonprofit in the human services space. And we had group homes where we would provide direct support professionals to be there around the clock for the individuals we were supporting who had intellectual and developmental disabilities. And certain group homes allowed for a sleep shift, right? They didn't need staff to be awake overnight, but they needed staff to be present in the home. And so in that circumstance, we had one rate of pay for all the hours that the staff were awake and performing work, and then we would pay them minimum wage for the hours in which they were sleeping. Okay, so that's important to make sure that you're paying employees at least minimum wage in any of these types of scenarios on your screen here. Okay. Okay, so that's the very quick and dirty gist of non-exempt employees. If we look at exempt employees now, the way I always thought about it in terms of the difference between exempt versus non-exempt is, along the same lines of innocent until proven guilty. Employees are non-exempt until they're proven to be exempt. And all employees are assumed to be overtime eligible unless they can meet certain criteria that proves their role to be considered exempt. And when we look at those criteria, there is a 3-part test that dictates who you as an employer can classify as an exempt employee, meaning that they're exempt from overtime requirements and you aren't on the hook to pay them OT. So at a very high level, those criteria are, generally exempt employees must be paid over a weekly salary threshold, which we'll talk more about shortly. They generally must be paid on a salary basis, and they must meet the job duties test for one of what are called the white collar exemptions. Okay, so we're going to break this down a little bit more. Again, in order to be covered by an exemption, employees must meet all 3 of these tests on your screen here. Okay, so just because they meet 1 or 2 does not mean that they can be classified as exempt. They have to meet all 3. So the first we'll look at is the salary level test. Generally, employees who are paid under the designated salary threshold cannot be considered as exempt, as we talked about. So if any employee makes under that salary threshold that we're going to talk about shortly here, they are automatically considered to be non-exempt employees and eligible for overtime. Okay. The second test is the salary basis test. And typically an employee who is exempt is paid on a salary basis if they can count on receiving a guaranteed minimum amount of work for any work week in which they perform work, right? So if they are answering emails, taking phone calls, performing any work within the work week, then they are guaranteed their full week's pay, except for very limited circumstances. Okay. And then the third test is what's called the duties test. And, what we see often is employers looking at, job titles or position descriptions, and saying, oh, yep, this person is an office manager. They have the word manager in their title. So they are of a certain caliber of, employee. And so they are automatically considered exempt. It is much more complicated than that. So job titles or position descriptions are, in all honesty, not that useful to determine exempt status. It is the actual job tasks and how the job fits into the employer's overall operations that matters. And that's what you have to look at. Okay. So I mentioned these white collar exemptions, and these are the exemptions under the duties test that you can see on your screen here. The most common white collar exemptions include executive, administrative, learned professional, creative professional, computer professional, outside sales, and highly compensated employees. There are other specific exemptions that are less common that you can find on the Department of Labor website as well, but these are the frequent flyers on your screen here. And what you need to do as part of the duties test is essentially take the responsibilities of each of your positions and compare them to the definitions of each of these exemptions to ensure that the role falls into one of these buckets. Okay, so as HR professionals, generally we fall into the administrative exemption, but there are varying degrees of, HR roles, right? So an HR admin may not fall into the definition of that administrative exemption, while a director of HR could, right? But again, it depends on the duties, right? Someone can be an entry-level HR person and, is just doing administrative work, but the employer calls them the director of HR. That doesn't matter. It matters about the work that is actually being performed. So if this isn't an exercise that you've done before now with all of your positions across your organization, now is definitely the time, and we'll talk more about that shortly, why it's the time. But this is something that we assist our clients with frequently at MP. So if you need any assistance with this or you don't know where to start, please don't hesitate to reach out, and we're certainly here to help. Some common exemption mistakes that I want all of you on this call to avoid. A, always classifying salaried employees as exempt. We talked about this. We now know that just because they're paid on a salary basis does not mean they're automatically considered to be exempt from overtime. Always classifying supervisors as exempt is also a common exemption mistake. Again, you have to look at the duties that are being performed and assess the level of independent judgment, decision-making, autonomy that is being performed through these positions to determine if they fall into one of those white collar exemptions. So just because someone has a direct report or two does not mean that they can automatically be classified as exempt. Again, you really need to look at the duties that they're performing. Again, classifying exemptions based upon job descriptions or titles only is a very easy way to have some mishaps here. Always classifying commissioned employees as exempt is also a common mistake. So again, generally commissioned employees, if they meet an exemption, will fall into the outside sales exemption. So you want to make sure that you're looking at the duties test for each exemption to determine whether or not they meet those. And then lastly, equating all jobs performed by highly educated employees as exempt positions, right? So if someone's coming in with, a certain level of degree or education, you can't just assume, hey, they're highly educated, so we're going to pay them on a salary basis and not pay them overtime, right? You got to look at that 3-part test to do that assessment. Okay, so those were common misclassification mistakes, some common overtime mistakes. So when you're paying out overtime, you certainly don't want to assume that managers are not entitled to overtime like we talked about. Making or allowing employees to perform work off the clock is a no-no. off the clock work for non-exempt employees does not exist, right? So you need to make sure that they're being compensated for all of the time that they're working. Providing compensatory time off in lieu of overtime. Comp time also doesn't exist for non-exempt employees, right? The point is that they are being compensated at time and a half for all of the additional hours that they're working. So if you have a comp time policy for non-exempt folks, that's definitely something to take a look at, and make sure that that is it, that you're paying overtime out appropriately. This is another big one, averaging the hours worked between 2 work weeks. So if any of you are, on a bi-weekly pay frequency, the Department of Labor looks at the overtime provisions in single work weeks, right? So if you pay on a biweekly basis, you've got 2 single work weeks within that pay period, and you can't just add up the hours and say, oh, you know what? They worked 45 in the first week, but they only worked 20 in the second week. So because they aren't making, or they didn't work more than 80 hours in a biweekly pay period, I don't have to pay overtime. That's not the case. The 45 hours worked in a work week does meet that overtime requirement because they worked over 40 in that week. So you would be on the hook to pay that 5 hours of overtime out. Okay. Also, not tracking hours actually worked. This can oftentimes come up in telecommuting, right? So you need to make sure that for all non-exempt employees, they are tracking all hours worked. That includes, a one-off email, that includes taking a kind of evening phone call, whatever. That is considered hours worked, and you need to make sure that that is tracked in your timekeeping systems. And then lastly, paying a fixed salary for a work week exceeding 40 hours, right? So, if you pay someone on a salaried non-exempt basis, and they're making a salary, which again, going back to our previous couple of slides, you can do that, but you still have to track their hours, and you still have to make sure that you're compensating a time and a half for all the hours they're working over 40. Okay. All right. I really don't like using scare tactics, so I'm not trying to instill fear in you over the next few slides at all. But, where we have some pretty significant changes to the overtime rule, you as employers may be in a position where you have to make some tough decisions on, how to assimilate to these new regulations. So I just really want to make sure that you have the appropriate information to be able to make informed decisions for your business. So the Department of Labor's Wage and Hour Division is the agency that enforces the FLSA. And where violations are found, investigators may recommend changes in employment practices to bring an employer into compliance if you're subject to an audit. And there is a 2-year statute of limitations that applies to the recovery of back pay, except in the case for a willful violation, right? Where you kind of know that people are misclassified and you're not paying overtime out appropriately, in which case a 3-year statute applies. In terms of penalties associated with this, willful violations may be prosecuted criminally and the violator fined up to $10,000. A second conviction may result in imprisonment. Employers who willfully or repeatedly violate the minimum wage or overtime pay requirements are subject to a civil money penalty of up to $1,000 for each violation. Okay, so I share this to say you don't want to be on the receiving end of that, right? And so it's really important that you make sure that you're addressing your classifications and payment of overtime in the appropriate manner. Okay, so now that we have all of the necessary background on the FLSA, let's talk about what is changing, what is the latest and greatest when it comes to this topic, because the new federal overtime rule is here. So this slide should look familiar. Let's remember back to this surrounding, exempt employees and the 3-part test that determines who can be classified as exempt. With these final regulations, there haven't been any changes to the salary basis test or the duties test. But there are some pretty big changes made to the salary level test for the executive, administrative, professional, and highly compensated white-collar exemptions. So that's where we're going to really be focusing on for the rest of this overview, okay? So again, the new federal overtime rule increases minimum salary levels for what's called the EAP exemption, which stands for Executive Administrative Professional. And the final rule also increases the minimum salary threshold for the highly compensated exemption. The final regulations increase the salary threshold in two phases. One happened on July 1st. At the beginning of this month, and we're awaiting the second phase that is slated to go into effect January 1st, 2025. The final regulations also implement automatic salary adjustments every 3 years, starting July 1st, 2027. And again, there have been no changes to the duties test, so all of those kind of provisions remain the same. So we're going to talk numbers, my least favorite subject. I joke around and say that I got into HR to avoid numbers, but here we are. Prior to July 1st, the standard salary level threshold was $684 per week, or $35,568 annualized. Okay, so prior to July 1, that was the standard. So anyone who made above 35,568 was a contender to be considered exempt because they met that salary threshold test, right? But again, you got to look at the other two parts of the test. As of July 1st, that threshold is now $844 per week, or $43,888 annualized, okay? So if you have anyone currently who is under that threshold, guess what? They no longer meet the salary threshold test. So they automatically now need to be classified as non-exempt if they are going to remain under that threshold. And then as of Jan 1, 2025, that's actually going to bump up again to $1,128 per week, or $58,656 annualized. So pretty big jumps here, right? And again, this is for the executive, administrative, and professional exemptions. So again, what this means, if you have any exempt employees making less than 43,888 as of July 1, or less than 58,656 as of Jan 1, 2025, you will either need to increase their salary above those thresholds or reclassify them as non-exempt employees and pay them overtime according to applicable overtime rules. Okay. For those of you who may have some employees classified as exempt under the highly compensated employee exemption, that salary threshold was previously $107, $432 annually prior to July 1st, and increased to $132,964 as of July 1. And again, bumping up even more to $151,164 as of January 1st, 2025. So some pretty steep increases all around here. So earlier I mentioned those automatic salary threshold updates as well. So, what does that mean for you looking into the future? The regs say that the salary level will be adjusted automatically every 3 years. And the adjustments will be based on the 35th percentile of full-time salaried earnings in the lowest census region for the EAP exemptions. And for the highly compensated employee exemption, this will be automatically adjusted based upon the 85th percentile of full-time salary employees nationally. And again, the first scheduled increase for this would be July 1st, 2027. So you certainly have some time before we cross that bridge, but certainly important to know and plan for as we look to the future here. All right, legal challenge. I do want to mention that these final regulations are being legally challenged. And some of you are probably having some deja vu back to when something very similar happened under the Obama administration. And, at the 11th hour, right before the new rules were about to go into effect, a Texas court halted things. And, we never saw the implementation of the new salary threshold after that. Under that administration until now. So there still, similarly, have been ongoing legal challenges from the start of the announcement of this new rule. Most notably, a legal challenge in the Texas courts. So again, deja vu. And, yet again, at the 11th hour before this rule was set to go into effect July 1, a federal district court in Texas did end up issuing a partial injunction to block the overtime rule. It's unbelievable because these agencies and courts really love to keep us on our toes, and these things always come out late in the day on a Friday afternoon. So, you gotta love that. And they really know how to, spice up your weekend, waiting with bated breath to hear about these decisions. But the difference this time, as opposed to under the Obama administration, is that this injunction currently only applies to the state of Texas and employees who are specifically working for the state of Texas. So no private employers, are subject otherwise no private employers are otherwise subject to the FLSA, are impacted by this court decision. It's only employees working for the state. So, in other words, the new exempt salary threshold as of July 1 is in place. And the January 1 increase is still scheduled as well. There are additional lawsuits still pending, which could very well change any or all of these new rules. So, there's still quite a bit that remains up in the air. But with that said, by failing to prepare, you're preparing to fail, as Benjamin Franklin once said. And I can't believe I'm saying that, because the amount of times that this came out of Phil Leonardi's mouth, my father, in my childhood, if I had a nickel for every time he said this, gives me shivers down my spine. But nonetheless, even though there's still quite a few question marks with this, you don't want to get caught flat-footed in January if things progress as planned. So there are definitely some steps you should be preparing to take in the coming months here. So in terms of a checklist to make sure you're ready to rock if things do proceed accordingly, the first thing you'll want to do is identify all exempt employees and current salary level. So who in your workforce is classified as exempt, and what are they being paid on an annual basis? Then you want to identify each employee who's below the new minimum salary threshold, right? So right now you got to worry about folks that are under that 43,000 and change mark. Jan 1, you'll have to worry about the folks that are under about $59,000 per year. Then once you identify those folks, you can kind of do a cost analysis, right? So identify the total cost that you would be on the hook for to raise those salaries to the minimum level. If that's not feasible, and you decide not to raise their salary, you'll then need to consider how to convert them to non-exempt status. What's really important when converting someone from an exempt to non-exempt status is a very careful communication plan, right? And so again, work with your HR advisor or HR team to really make sure that you are nailing that communication plan down, so that things go off without a hitch, and you don't get questions from employees about, well, why now, right? And we'll talk more about that shortly. We'll talk more about that now, actually. Now is a good time to review all of your exempt jobs for compliance with all of the criteria, right? So, you have identified, the folks who fall under the salary threshold. That's pretty straightforward to explain to employees, right? Like the regulations have changed. You were under they raised the salary threshold, making anyone who makes less than that salary threshold a non-exempt employee now, right? The trickier conversation is for folks that may be over that salary threshold, but what if they don't meet the duties test, right? So now is a good time to look at that duties test, look at that 3-part test, as in a comprehensive way, and assess all of your positions to make sure that you have them classified properly. Because what can happen is, if someone's making, let's say someone's making $65,000, right? They're over that salary threshold, but the duties that they're performing don't fall into one of the white collar exemptions. right now you have the narrative working in your favor to say there are regulatory changes happening at the federal level that have caused us to go and look at this and make some organizational changes. Okay. The beauty in using this narrative is, if you go to employees and mention that you're reclassifying them from exempt to non-exempt, it may bring up some questions in their mind to say, well, my job hasn't changed at all over the past 4 years, but I wasn't eligible for overtime until now. So why is that, right? And, as we went through in terms of the penalties and fines, there is multiple year statute of limitations on those things, right? So all it takes is for someone to get a little bit curious about, hey, the nature of my job hasn't changed. Why have I been putting 60 hours a week in and not getting paid overtime until now? That can bring up some risk for you as an organization. So now is a great time to assess those duties, make sure that you're classifying people properly. And if you recognize that folks do not meet the duties test, you have that narrative working in your favor to convert them to non-exempt. Now, in the event that you need to reclassify some of your employees from exempt to non-exempt, there are several considerations. So, they were making a salary, but now they're need to, have an hourly rate established, right? To understand what their regular rate of pay is. What is that hourly rate going to be? You'll also need to determine what the employee's regular rate is, since this is the rate in which employees are paid out overtime against. So if you have employees making multiple rates of pay based upon, the job that they're performing, or if you have employees earning, non-discretionary bonuses, etc., these are all factors that play into the employee's regular rate. So you'll definitely want to be sure that that's being paid out within compliance. Again, that homework item, go back and look at that regular rate. Your exempt employees generally don't need to track their hours worked, but now if they're being switched to non-exempt, they will need to track hours worked and be compensated for those hours. So making sure that you have the appropriate mechanisms to have your non-exempt employees track their hours and properly train them on how to track their hours will be important. Some of you may have employee benefits that could be impacted by a transition from exempt to non-exempt employee, depending on how your policies are written. So make sure that you can consider those implications as well. And then finally, you have to consider your overtime costs. So at the federal level, again, overtime kicks in for all hours worked over 40 in a work week. So depending on how much your employees are working, that could, certainly bring some additional financial liability to the organization. So, making sure you have strategies surrounding how you'll be managing those overtime costs will be imperative as well. And the last nugget we wanted to mention on this topic today is how important it will be to train your managers and supervisors on how to properly manage non-exempt employees. So you'll want to make sure that they're keeping track of scheduled hours and not allowing employees to, work mass quantities of overtime without leadership approval. How do they go about getting approval from employees to work overtime? Are they able to make decisions when it comes to working overtime, or does that need to go up the chain of command? So what is their autonomy when it comes to approving their employees overtime? Making sure that they're educated on timekeeping procedures. So how are employees expected to track their time? When do employees need to submit their timekeeping? When do managers need to go in and approve the timekeeping records? Also making sure that they're aware that they may need to provide non-exempt employees with uninterrupted meal breaks and rest periods. And then making sure that they are aware that there's no such thing as off the clock work for non-exempt employees. They need to be compensated for all time worked, including if they're doing work on a personal device as well. So you could see here that there are quite a few considerations, and your managers and supervisors are on the front lines, and the ones, really with direct visibility into what's going on when it comes to wage and hour practices amongst their team. So want to make sure that you provide them with the tools in order to be successful and to mitigate the risk of missteps that, could potentially bring liability to the organization. All right, so that's that on FLSA. Next topic, I'm sure you've heard about this one as it has been highly publicized. We have the ban on non-compete agreements. So The Federal Trade Commission has issued a final rule to promote competition by banning non-compete agreements nationwide. And essentially it says that non-competes is an unfair method of competition for someone to enter into, enforce, or represent to someone that they are subject to a non-compete. So the FTC's argument is that non-compete clauses, can suppress wages and harm competition by blocking workers from pursuing better opportunities and by preventing employers from hiring the best available talent. So we're currently looking at a September 4th, 2024 effective date for this. Some more details. All existing non-compete agreements are unenforceable after September 4th. So that means that your current employees under non-compete agreements, as well as former employees who are under non-compete agreements, are subject. There is one exception to existing non-competes that covers senior executives earning more than $151,164 annually and who are in what are considered to be policy-making positions. So if you currently have a senior executive that meets this criteria, you can continue to enforce their non-compete. However, after September 4th, you will be unable to institute new non-competes for any worker, including senior executives moving forward, if this goes into effect. Now, you might be thinking, the silver lining to all of this, the good news is that confidentiality and non-solicit clauses are safe. However, that might not be entirely the case. Essentially, all clauses, any clause that has the function of preventing an employee from working somewhere else, would be considered to have the same effect as a non-compete and enforced in the same way. So just because this rule specifically uses the term non-compete agreement, that doesn't mean that the other clauses you have in place can't be affected by these rules if they're restrictive in that way. The definition of a worker is broad under these rules as well. So the term includes an employee, independent contractor, extern, intern, volunteer, apprentice, or sole proprietor who provides a service to a person. Again, this applies to both current and former workers and is not limited to the employer-employee context. The rule does state that you are required to provide written notice to any current and former worker who is currently under a non-compete, letting them know that their agreement is no longer enforceable. So the one nice thing about this is, I guess, the FTC did provide some model notice language, or you could always reach out to your counsel to draft those notices. Now, with this being said, I wanted to make sure that you were aware that there is potentially a written requirement, a written notification requirement, but certainly pump the brakes before you go issuing any written notices. At this time, we'll talk more about why in the next few slides here. Okay. Some FAQs. So is the rule retroactive? The FTC says yes for all workers other than senior executives with current agreements in place. Okay, so any existing or former employee, it does apply retroactively. Who is a senior executive? The FTC defines a senior executive as someone who whose total compensation exceeds $151,164 in the preceding year, is in a policy-making position, and has policy-making authority, which means final authority to make policies that control significant aspects of the business. So the way it looks right now is, they have to meet all three of those criteria in order to be considered a senior executive under these definitions. And the FTC has come out and said that they're estimating that this applies to fewer than 1% of workers, right? So not a whole lot of senior executives will be able to continue to with their non-compete, having that be enforceable unless they meet those three criteria. What about confidentiality and non-solicit clauses? Again, we talked about this. I'll make sure that you get this information in the slides, but it doesn't necessarily mean that these clauses are protected if they have restrictive language in them. All right, another legal challenge for us. So just like the overtime rule, we have another disclaimer with this one too. Lawsuits were very quickly filed against this rule, arguing that the Federal Trade Commission lacks the jurisdiction to enforce something like this. And, it does sound like that might be a strong argument. There are lawsuits in a Texas court that granted a preliminary injunction against the FTC's rule banning non-competes. It ultimately delayed its implementation for just the plaintiffs involved in that case. So the injunction does not currently extend to other employers, but a final decision is expected by August 30th. They're giving us a whole handful of days between August 30th and September 4th to spring into action here. So kind of them. But that final decision may affect the broader applicability of the injunction universally. So we'll have some more certainty later this summer about whether the rule may go into effect depending on the results of that case. But again, that said, even if it doesn't go through at the federal level, it wouldn't be the most surprising thing in the world to see more states adopting something like this at the state level. We've already seen some states putting restrictions on non-compete agreements. So there could be something similar implemented at the state level at some point. So again, we're waiting with bated breath to see what happens with this one, but in the meantime, there certainly are some preparations you can make. First is taking an inventory of existing non-compete clauses in your workforce. What current and former employees have a non-compete clause in play right now. Prepare, but do not yet issue those required notices. Review your non-disclosure agreements and policies to take a look at that language. Ensure your trade secrets and confidential information is protected through your policies. Do a legal review of your customer and employee non-solicitation provisions. And you can certainly work with an attorney to consider alternative agreements if that's something that you wish to do. So again, these are things that you can be thinking about in the meantime and can be working on in the meantime. But we will see towards the end of this summer what is in store when it comes to that final rule. All right, and last but not least, the final topic we'll be talking about today is the Federal Pregnant Workers Fairness Act. This is generally the Pregnant Workers Fairness Act requires a covered employer to provide a reasonable accommodation to a qualified employee's or applicant's known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. And the PWFA applies to only accommodation. So there are other laws that the EEOC enforces that make it illegal to fire or otherwise discriminate against employees or applicants on the basis of pregnancy, childbirth, or related medical conditions. But for the purposes of today, we're just going to be focusing on the PWFA and the reasonable accommodations piece. So the PWFA went into effect on June 27th, 2023. On April 15th, 2024, the EEOC issued its final regulation to carry out the law, and the regulation went into effect on June 18th. And the final rule really provides clarification on covered employees, covered limitations, and medical conditions, and how individuals can request reasonable accommodation. So it just provided some additional clarity. Importantly, the final rule also includes numerous examples of covered conditions and reasonable accommodations to illustrate how employers may handle requests for accommodations. So it gives you some good food for thought if and when these situations come up. So in terms of what the PWFA prohibits, covered employers must not fail to make a reasonable accommodation for the known limitations of an employee or applicant unless the accommodation would cause an undue hardship. They must not require an employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process, which is a mutually beneficial conversation between you and the employee. So you can't force someone to say, this is the accommodation that you need to take. You need to engage in that interactive process, similar to how you would do under the ADA, reasonable accommodation process. Employers cannot deny a job or other employment opportunities to a qualified employer applicant based on the person's need for a reasonable accommodation. They cannot require an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working. Can't punish or retaliate against an employee or applicant for requesting or using reasonable accommodations for and no limitation under the PWFA, for reporting or opposing unlawful discrimination under the PWFA, or for participating in a PWFA proceeding such as an investigation. And covered employers cannot coerce individuals who are exercising their rights or helping others exercise their rights under the PWFA. Okay, so steer clear of those 6 scenarios there. There are some specific modifications which the EOC automatically considers reasonable accommodations in virtually all cases. So these accommodations are listed on your screen here, which would be allowing an employee to carry or keep water near and drink as needed, allowing an employee to take additional restroom breaks as needed, allowing an employee whose work requires standing to sit and whose work requires sitting to stand as needed, and allowing an employee to take breaks to eat and drink as needed. So essentially, if any employee requests any of these accommodations listed on your screen here, these are almost always going to be considered to be reasonable, and you will be required to accommodate. On your screen here, you're going to see some examples of reasonable accommodations under the PWFA. For the sake of time, I won't read through these all, but some examples that you may want to consider would be things like longer or more flexible breaks, changing a dress code policy, or providing safety equipment that fits for the employee, temporary reassignment of their role, providing leave for healthcare appointments, and more. So you'll get a copy of these slides. You can look through all of these. And this list just provide some examples. There are certainly many other reasonable accommodations that exist. And it's also important to recognize that a worker may need different accommodations, at different times during the pregnancy or after childbirth. So you want to make sure that you're engaging in that interactive process on an ongoing basis. Unlike the ADA, the Pregnant Workers Fairness Act states that an employee can meet the definition of qualified, even if the employee cannot perform one or more essential functions of the position, if the employee meets 3 conditions. The first being the inability to perform an essential function that's for a temporary period. Second is that the essential functions can be performed in the near future. And the third is the inability to perform the essential functions can be reasonably accommodated, right? So under the ADA, it makes it clear that, you don't have to remove essential functions from people's role as part of a reasonable accommodation. The ADA is to make accommodations in order to help employees meet the essential functions of their job. But this does take a little bit of a different turn and says that if the essential function is only going to be unable to be met on a limited or temporary basis, that could be something that needs to be done under the Pregnant Workers Fairness Act. Okay, so the final rule does not provide a strict definition of the word temporary or in the near future, although, the final rule does state that any definition of in the near future as less than the duration of a full-term pregnancy, which could, so up to 40 weeks generally. All right, so we wanted to give you some tools in order to respond to requests for reasonable accommodations. The final rules emphasize that informing the employer of the limitation and requesting a reasonable accommodation should not be complicated or difficult. Employers should allow employees to communicate their limitations and requests for accommodations through various avenues or means without the requirement for, a specific format or form. And an employee does not need to specifically ask and use the term accommodation to trigger an employer's obligations under the PWFA. So, if they're not specifically saying, I need a reasonable accommodation, you still need to have your eyes and ears peeled for when you may need to engage in that interactive process. So of course, the first step is the notification of a need for an accommodation, and that notification, can come in multiple different forms as laid out on your screen here. Once you've been notified that the employee is in need of an accommodation, you're going to engage in the interactive process just as you would if you are navigating through an ADA situation. Work with the employee to understand what accommodations they may need and determine whether or not it's something that can be implemented. And then once you determine, yes, this is something that we can accommodate, or no, this is something that we can't accommodate due to undue hardship, you of course want to provide the employee a response regarding that accommodation. Okay, and generally these types of accommodations under the PWFA can be granted after those simple exchanges of information between you and the employee, through a brief conversation and or through an email exchange. We are coming up on time. I'm racing the clock a little bit, so I'm going to skip through these FAQs, but they are in the slide deck for you to review once you get a copy of the slides. And the Department of Labor also has a really great FAQ document that I highly encourage you all to go and take a look at, especially in your industry where, it is, very much female dominated. You have these situations come up pretty frequently, right? So it's really good to familiarize yourself with these provisions. Some things to remember: workers do not need to use specific words to request an accommodation and begin the interactive process. Limitations may be minor and may be associated with an uncomplicated pregnancy, and may be required you may be required to make accommodations that are easy to make, right? So someone doesn't necessarily need to be on bed rest or have pregnancy complications in order to be protected by this. A worker may need different accommodations as the pregnancy progresses, as they recover from childbirth or the related medical condition improves or gets worse. And then this last bullet is a really helpful website called the Job Accommodation Network, or JAN, and it's a free expert confidential service that helps workers and employers with reasonable accommodations. I highly recommend you bookmark this if you don't have it already. It breaks down the different disabilities and gives you as the employer recommendations on what reasonable accommodations you can make for those specific scenarios. All right, last but not least, a couple of cautionary tales. I wanted to end with a little bit of story time to share a couple of situations where other employers in the home care industry have recently been in the legal hot seat. The first claim I wanted to talk about is an immigration-related discrimination claim. This was a national home health care company that the Justice Department ended up securing a settlement with recently, and this company rejected the valid documentation of a non-US citizen worker and required lawful permanent residents to prove their continued permission to work. So, through the investigation, it was concluded that the company improperly rejected a worker's valid document based upon their citizenship status. So specifically, they determined that the company rejected the worker's employment authorization document because the last name on it was different from the last name on her driver's license and social security card, even though the company accepted documents from US citizens under similar circumstances and believed that the EAD reasonably appeared to be genuine and relate to the worker. Okay, so they treated this person differently because they were a non-US citizen, and that is considered to be a discriminatory practice. The investigation also determined that the company routinely required lawful permanent residents to present unnecessary documentation when their permanent resident cards expired, which is actually not required by law. So anti-discrimination provisions prohibit employers from rejecting valid documents or from asking for specific or unnecessary documents because of a worker's citizenship or immigration status. If a lawful permanent resident provides an unexpired permanent resident card to prove their permission to work and authorization to work, employers are not permitted to request new documentation once that expires. Okay, so you never have to re-verify someone who has a permanent resident card. So moral of this story is don't do that. Also make sure that anyone in your organization who is acting as an authorized representative on behalf of your organization for I-9 purposes is properly trained on I-9 compliance, because it can be complicated. And then our last cautionary tale here is an overtime lawsuit. The issues that they found in this case were separately tracking day and night shift hours in a single work week. Those two shifts were separately tabulated on paychecks and not combined for overtime purposes. They required employees to clock out when traveling between patient locations. And they also found that occasional med admin wasn't compensated, and it ended up in a $62,000 settlement. So essentially what happened with this one is company compensated daytime and evening hours at 2 different rates. So the aides earned between 12 and 13 per hour during daytime work and 10 per hour for nighttime work. And although, the company tracked both kind of categories of work, the workers said the 2 shifts were separately tabulated on paychecks, resulting in workers only receiving straight time pay, even when even though if they combined those 2 categories, the weekly hours exceeded the 40-hour overtime threshold. Again, they were also required by the company to clock out and back in when they were traveling, which is a no-no. We know that travel time is compensable. And the workers also claimed that they occasionally had to give medicine to patients under a coworker's care if that employee, lacked the proper certification or training, and those hours were going untracked, and they should have been compensated. And it would have brought them over the overtime threshold. So again, it's critical that you ensure your employees are classified appropriately as exempt or non-exempt. And for those non-exempt employees, you need to make sure that they're being compensated in accordance with minimum wage and overtime requirements. Holy moly, what a marathon here. All right, I apologize for breezing through the end, but I know we're at time. Lauren, do we have any burning questions that we want to answer?
No, thank you, Amanda. So I know she went over a lot of information. So if you still have any Q&A, all of our presenters' contact information is going to be on the slides that are sent to you after this. So once again, a big thank you to Amanda, Celeste, and Harrison. To learn more about MPHR's full service solutions for 2024 and more, you can visit our website at mp-hr.com. And if you'd like to know more about joining the Home Care Alliance of Massachusetts, visit www.thinkhomecare.org. I'm going to put those in the chat right now for you. Be sure to join MPHR for our upcoming webinar, Pay Transparency, Legal Insights, Proven Strategies, and Compliance Updates. Visit our website to register to see the full calendar of upcoming events and available resources. Once again, we will be sending out a recording of today's webinar along with the presentation slides that has everybody's contact information on the second slide there. Thank you for joining us and have a terrific day, everybody.
Thanks, everyone.
Thank you.